Honor, just for context, right? You said that you're not in the defense chain.
Correct.
You're not in the trial counsel chain.
Correct.
You're not in the LSC chain of command.
Absolutely.
Are you aware that Commander Ely had requested the vaccine prior to the trial?
I was not. And was he denied that request, counsel?
Your Honor, Commander Ely has not been vaccinated.
Okay.
All right, Your Honor. This is going to make a oral motion for you to recuse yourself from this case. We'll have 3 reasons that will cite related to the voir dire we just went through with relation to the COVID-19 vaccination and the trial counsel. And then I will cite additional reasons and arguments for your refusal in this case. All right, so first, the COVID-19 vaccination that you yourself and the trial counsel have received, your efforts to do so and your knowledge of the trial counsel's vaccination. Reason number 1 is the appearance of impartiality of cites at RCM 902. Plain language right from the NCN of the 902. Military judge shall disqualify himself or herself in any proceeding in which that military judge's impartiality might reasonably be questioned. Cites the case law here. Just a little explanation on that. What would appear to a reasonable person knowing all the circumstances is Milgeberg, 486 U.S. at 860 to 61. Also, from United States versus Health, 668, F.2B 1238. Site 1271. All that must be demonstrated how recusal is a showing of an appearance of bias sufficient to permit the average citizen reasonably to question the judge's impartiality. This is in asking what would cause a reasonable person to doubt the judge's neutrality, we recognize that somewhat subjective character of this ostensibly objective test. It's PepsiCo Incorporated versus McMillan, 764 F2D, 458 F, 460 at 738 from 1985. From that same case at 461, even in the case of a scrupulous judge with no intention of parlaying his judicial authority into a new job, the risk that he may appear to have done so is unacceptable. Simply put, a judge cannot have a prospective financial relationship with one side yet persuade the other that he can fairly judge in this case. And so, we'll go here. Parliamentary 440 U.S. LSPC 60 at 921.
Case law explains it.
One could reasonably question the military judge's refusal to consider an appearance may be all there is, but that is enough. United States, that's 253, that's 3 at 115. So, Your Honor, you have received a material benefit, the trial counsels have received a material benefit prior to this case, and you have failed to disclose it to the defense. Yet it was disclosed, not only were the trial counsels vaccinated, but your emails were with folks, as you said, not in your chain of command, communicating with the folks that are in the trial counsel chain of command. You took no action to see that anybody on the defense team, or most importantly, Commander Ely, was vaccinated. Yet you cited in your email, you understood that Commander Blackmore had done a lot of legwork for the trial counsel to support the staff of shooting shots. And then it went a long way to continue the military justice mission, and the BJAG specifically says there was a need for this. Now we have a motion. Your email clearly shows you knew and were aware that you showed gratitude for the fact that the trial counsels were vaccinated in this case. That is a bias of yours and the trial counsel's material benefit. It probably impacts your calculus because you don't have the same COVID concerns. It's no longer a common fear for you. And as we said earlier, despite sending an email in January and having a native due prior to the day and issuing the COVID mitigation order, you failed to disclose both your vaccination and your knowledge and gratitude for the trial counsel's vaccination. The fact that you didn't disclose would lead a reasonable person to believe that you intentionally chose not to disclose it to us. Second, as we move forward now, there's clearly not a level playing field. You were aware of that playing field coming in to this courtroom today. You were aware that the trial counsel had been vaccinated. The trial counsel in 3 different locations. Lieutenant Smith is stationed in Boston, Lieutenant Tyler is stationed in Alameda, Lieutenant Frodo is stationed in Norfolk. You're dealing with different medical treatment facilities or distributions of the vaccine, yet all 3 of them were vaccinated. You were aware of that. And now they sit here today and they don't have to worry about getting COVID-19 during this trial. They don't have to worry about potentially contracting a disease that is killing currently 400,000 people a day, and the infection rate is over 200,000 people per day in our country. So while defense moves forward and we wear our mask and everybody in this courtroom wears their mask, we have to be concerned. I had to take a flight here yesterday. We will all be traveling to Groton here soon. I have to take another flight to Groton. I have to take a flight to get home to Chicago. And I've got to spend 25 days TAB for this trial. My client has, most importantly, to take travel up to the Groton, and we have to sit in court here for 2 weeks, and we all have to be concerned about the possibility that we might contract COVID-19. Meanwhile, the government is free from those concerns and worries as they are vaccinated. They will spend 0 mental bandwidth being concerned about contracting COVID-19. Finally, this email alone is going to require additional discovery in this case. As the BJAG and the Coast Guard was aware that you and the trial counsel had been vaccinated, made no questions or inquiry about the accused or anybody on the defense team. And he specifically said that there was a need for you and trial counsel to receive these vaccinations. That calls into question, obviously, apparent UCI, but potential actual UCI. Again, this goes back to number 2. They're going to have we don't have a level playing field here. We have an additional serious concern about our health, our client's health, going forward through this trial. And so, the UCI, you're just meddled right into it. You're sending these emails to leadership within the trial counsel, as you said, you're not their chain of command, but all these folks on here are trial counsel chain of command. including, and then to the GJAG, who is citing the need for you and the trial counsel to be vaccinated. Those three reasons are tied to the vaccination and are alone enough, Your Honor, for you to recuse yourself in this case. We'll cover just a couple extra items. At this point, we're making this motion, so we'll put everything forward and put it on the record, our reasons for it. I'll start with the most recent. The continued allowance of Commander Lance with the SBC for EE to participate in RCM 802 conferences over defense objection. EE is no longer on the charge sheet, and we have requested during our most recent 802 that they not be allowed to participate and be allowed to have a number of objections. There has been a good cause double standard throughout this case. So the defense filed several motions that were litigated in our November Article 39A. For those motions, we were required to decide good cause, decide good cause for them. However, in two of the motions, you denied our motion alone. You said you did not show good cause. That was December 2nd ruling in our motion for preemption and our December 12th, your December 12th ruling on our UNC motion. You denied both of them because you did not cite good cause. However, we cited in our 6th October defense motion for appropriate relief continuance request no less than 10 times that the trial counsel had failed to provide discovery by the court-ordered date. You did not require them to show cause then or after we filed this motion for those 10 times. And if you look at that motion, there are other instances where we believe that the trial counsel was not complying with court order. But I specifically cite 10 because there are 10 that we cited here where the court said, on this date you shall do this, and it did not happen. And you did not require this. Additionally, as cited in our 22 October defense motion to dismiss, on 1 October the court denied the defense motion to dismiss on 28 September, but ordered trial counsel for the second time to confirm with BCF that no records exist that Laureano encouraged his children to fabricate allegations against Commander Ely no later than 9 October. And then we filed this motion on 22 October, 13 days after that. And as of that date, the government had not complied with that order. You did not require the government to show good cause. On 21 September, you ordered the government to produce all treatment records pertaining to Emmy's head injury suffered in December of 2011, no later than 15 October. As of the filing of this motion on 22 October, the government had not done so. You did not require them to show good cause. We'll brief it to SBC, Lieutenant Callahan, SBC for Emmy. A defense motion for discovery for the November Article 39A. Findings of fact 33 through 41 cited the back and forth that Lieutenant Callahan had with this court, where the court ordered her to provide her answer about Emmy's MRE 513 waiver for purposes of the in-camera review. Lieutenant Callahan did not meet the court's order to give an answer about that in-camera review 4 times. 4 times the court gave a date, and 4 times Lieutenant Callahan did not reach that date. Not once did this court order Lieutenant Callahan to give good cause. The disparity, the double standard of when the court has chosen to order statements of good cause and when it has not have shown a clear double standard and a bias against the defense. And finally, Your Honor, actually two items. Your nonverbal actions during Article 39 seconds. You have sighed, rolled your eyes, and put your head in your hands on more than one occasion during defense arguments and witness questioning. Those actions would call into question your impartiality in this case. And finally, related back to the COVID-19 vaccine and what you put on the record for 802. We filed our motion to abate on 4 January. In a very loud and what seemed like angry monologue with defense, you told us that you would not read our motion. Qualified that nicely with would not read our motion until you had received updates on the status of Ms. Wong's contracting. Given the COVID-19 vaccination issue, this becomes even more. It calls into your impartiality even more. So you told us that originally you received the vaccination on 8 January, but you didn't receive it on 15 January. We filed that motion on 4 January. So in the midst of while you were trying to get a COVID-19 vaccine, which nobody on the defense was refused that, and as you said, for travel for an upcoming trial to continue the military justice mission, and as the DJAG said to me, you refused to consider or read our motion that would have potentially paused or delayed this case and removed the immediacy for you and trial counsel to receive vaccination. John, for those 7 motions, we ask you to recuse yourself. That's our oral motion for you to recuse yourself.
Thank you, counsel.
Your Honor, may I please know?
Sure.
That's all, Your Honor.
Yep. Trial counsel?
If I may continue with the voir dire.
Sure.
Are you aware that not all members of the trial team have been vaccinated with the COVID-19 vaccine?
I am not.
Are you aware that of the members that have been vaccinated, they have not completely completed the vaccination regimen?
I would assume so, since it's going to require 2 shots.
And are you aware that even with 1 dose of vaccine is not 100%, that you can still contract COVID-19 without having the
That is my understanding.
Now, do you have any power or control over who gets the vaccine?
No.
Do you care more about the trial team than the defense team and the accused, and the bailiffs, the court reporters, and the SECs?
No.
Thank you. Your Honor.
Yes.
I don't have any different questions, but to make the point that defense certainly understands how both the Pfizer and the Moderna vaccine work, that they require 2 shots. That's not the point. If needed, we could supplement the record with something from the CDC or the FDA about the percentage thus far based on the case studies and the trials that have been done of effectiveness after the 1 shot. I won't guesstimate, but they are better than not having a vaccine at all. And the other point is, that I would argue is that was made clear through the board here in the record is that both trial counsel and the military judge have jumped the line to get their vaccinations. They did not receive, yourself or trial counsel did not receive your vaccinations in the natural order of which you would have otherwise received it.
Trial counsel, do you have any argument in opposition to the motion?
Yes, Your Honor. This next question should fail. The court has not demonstrated any bias, and there's no reason for Your Honor to refuse yourself.
Okay. Okay, counsel, what I'd like to do, we've been on the record for about 50 minutes. I'd like to take a recess, air the court out. I will consider this motion during the recess. As a result, I'm going to need a little bit longer, 30 minutes, at least for me to start considering the motion, and then we can come back on the record. Does that sound like a way ahead?
Yes, Ron. Yes, sir.
Okay, let's go to recess. Everyone carry on, please. Present when the court last recessed, or again present? Over the recess, the court has reviewed the case law, the RCMs, and the factual matters raised by the defense regarding their motion to recuse, and the court's going to issue an oral ruling at the moment. So before this court is a motion by the defense for the military judge to recuse himself. The basis for the motion is a couple reasons. The first being the military judge's interaction with the Legal Service Command regarding the COVID vaccine and the vaccination of trial counsel and the military judge. Also, put broadly, the defense raises issues of the military judge being unfairly unbalanced towards them regarding the standards that he has held counsel to throughout litigation of this court. The court has considered the arguments of counsel, applicable case law, and hereby denies the motion to recuse. Military Rule for Courts Martial 902 states in pertinent part, in general, a military judge shall disqualify himself or herself in any proceeding in which the military judge's impartiality might be reasonably questioned. The discussion after the section of RCM 902 provides further guidance about how this rule should be construed. It states that a military judge should carefully consider whether any of the grounds for disqualification in this rule exists in each case. The military judge should broadly construe grounds for challenge, but should not step down from a case unnecessarily. Therefore, a military judge must consider the facts at hand and determine whether there are grounds for questioning his impartiality. The standard used on appeal to determine whether the impartiality of a judge can be reasonably questioned is an objective, reasonable person standard, which basically states that any conduct that would lead a reasonable man, knowing all the circumstances, to the conclusion that the judge's impartiality might reasonably question, is the basis for the judge's disqualification. Now, I'll note that RCM 902 is based on the federal statute found in Title 28 of the United States Code and the ABA Code of Judicial Conduct. And that is found in the appendix to the RCMs. Therefore, case law in these two provisions can further assist the court in determining whether it was proper for the judge to recuse himself. Every appellate circuit has adopted the reasonable person standard when analyzing recusal cases. In evaluating disqualification under the federal law, the question is whether the court is biased against a party, not whether the court is annoyed with the party's counsel. And I cite Gomez v. St. Jude Medical Diagnosis Division, Incorporated, 442 F. 3rd 919 from the Fifth Circuit in 2006. Now, as applied to this case, the court makes the following findings of fact. The court was alerted by the LSC that the vaccine is available at Base Portsmouth. The Coast Guard Trial Judiciary, as I've stated on the record, is a small judiciary of 3 full-time judges with no administrative support offered. And again, all of the judiciary is based out of headquarters unit. I am physically located. My site of duty is the tax duty in Norfolk. And my administrative support is found at Coast Guard headquarters. Of course, locally I receive medical treatment at Coast Guard Base Portsmouth. Coast Guard Base Portsmouth is the medical facility for all Coast Guard personnel in the greater Hampton Roads area, which includes the Legal Service Command. I found out that the Legal Service Command had put me on a list of names that had been sent over to the Base Portsmouth Medical Department head. I received an email from them on a few days before the 8th, I believe the 6th, stating that I would be able to get the vaccine. On the 8th of January 2021, I sent the email to, again, on the 2 line was Commander Kismet Wonder, the Executive Officer of the Legal Service Command. CC was Mr. Calvin Lederer, SES, the Deputy Judge Advocate General of the Coast Guard. Captain Bowen Speedback, the EA to the Judge Advocate General. Captain Ted Fowles, the Chief Trial Judge of the Coast Guard. Captain Richard Batson, the CEO of the LSC, and Commander Brian Blackmore, the Chief of the Coast Guard, the LSC's Military Justice and Command Advice Division. He is stationed in Alameda, California. Again, the email states, Kismet, I just wanted to write a quick note of thank you for your assistance in advocating with Base Portsmouth on my behalf for a COVID vaccine. I know it took some effort. The second paragraph states, I understand Brian Blackmore did a lot of legwork in Alameda to ensure the TCs and the support staff received shots this week prior to travel for an upcoming trial. Please pass along my gratitude. These efforts go a long way in being able to continue the military justice mission. Thanks again, VR Paul. Mr. Lederer responded to all the parties, and I will note he copied Mr. Thomas Cook, who is the Chief of the Coast Guard Defense Services, and Ms. Elizabeth Murata, who is the Chief of the Special Victim Counsel Program in the Coast Guard. His email states, my thanks to and also for the rest of you who identified the need and have been working the issue. I did not alert the Defense Counsel nor the SVCs in this case. The intent of that was they were not inside my chain of command. I didn't feel like I had any authority to let them know, let them order them in some way to seek out the vaccine. I will also note that the vaccine is not mandatory for military personnel. It is purely voluntary. And I will also note that I did not advocate at any time for trial counsel to get a shot in this case. Regarding the 4 January 2021 802, I was yelling during the 802. My voice was raised, and I was directing that yelling at both parties. I was frustrated. And I was frustrated because on my 16 December email, I had told the parties to let me know regarding Ms. Wong if there was any other issues in it, to let me know those that immediately. I did not get that notification, and I was very upset at both parties. However, I like to practice the fact that I do get mad sometimes, but I'm very quick to get over it. And the following days, I did clarify my position with counsel that, of course, I would read their motions, but that I wanted to get more facts regarding the background of Ms. Wong's contract situation before that. As for my body language, although I aspire to be stone-faced up on the bench, that is not always accomplished, especially during Article 39A sessions outside the presence of the members. Facial expressions